Ebusafo ene eye dasronko ebema abronye DC because na ene na court say omepiemu ewo court na yendi na asem fefefe because of you see we breaching the peace of the country. Yin na any peace ko yin peace crisis ya say abronye DC a breach, but they are saying say abronye DC a breach the law and sorry the peace of the country. Sa petition we ene de abo abronye DC na ena courts ema kwan anase judge na kunyum ema kwan se abronye kwame bafo ensa mepiemu ewo Accra Circuit Court na ebusofo wakwakopiemu ho na sisi AG Odame odiamma no woto say MPP for the say be can nim the four party MPP for will be asebi enya asem ketua. So right now no AG the informations and as evidence upon evidence say kwame bafu enye boni bia sisi aye kwakopiemu Accra Circuit Court na ya ebusofo jubilation kese pa na ekwo na so ama NDC for so omonti ase and then also say abronya DC akasetia His Excellency the able and competent President John Dramani Mahama when I'm so into no more toss no nam so ama abronye eputi ama judge otina kunyem say we enye sensible thing because yebesha emre and former president Nana Adams Kufuor insem bia ni wa yanti wo kroma say especially okujeto ablakwa ebusafo edidi atemo odi Nana Adams Kufuor former president na nya asem keto enye ono nko even Sami Jemfi minister for gold board and also to say NDC for the fa to say 99.9 AD His Excellency former president Nana Adams Kufuor atema na nya asem keto. So right now no omo bibia abanye DC aya omo china omo tosi ne san kame ho ni nyina yenkoti nsema AG Odame edituja na answer and make sure to subscribe to Odame TV, you like, you comment, and please make sure you are going to share videos to a lot of people. Sebiam subunya elkoso ewe mangana muzi yesho nyekuti marcia medas
fear and panic. He alleges that the accused person, that is Abronye DC, stated that the IGP, that is Yohonu, had met with NDC operatives in Akwetia in the turn-up to the elections, the Akwetia by-elections, which obviously would be the argument of the state in this instance that may have created fear and panic. And secondly, on this, the particulars of the second offense is that he, on his show, made certain offensive statements against the IGP.
About 29 years old?
He's not 29 years old. In fact, there were some inconsistencies here. It provided that he was 29, and then here it said he was 37.
Okay.
But those are
all right.
That
matters. Okay.
They may deal with, and that he made certain statements that IGP Tete Yohono collected bribe
from
from members of the. He says he made a statement that he is the most corrupt IGP in Ghana's history. And so, as to the specifications of whom he collected the bribe for and for what specific purpose, we do not know. But he says he's a bribe taker and he is corrupt in nature. And so, per the police charge sheet, they are claiming that these are statements that are not conducive, or that are conducive to the breach of the peace. To which these are statements that carry or have the propensity of causing a breach or a breakdown in peace and security, which is quite interesting. And so at the last court sitting, when they went to court the last time, the lawyers for Abronye made an application for bail. In fact, he appeared because he had been apprehended and kept for 48 hours. In Ghana, the law is that if you are caught for any offense, you must be kept for 48 hours maximum before you are brought before a court of competent jurisdiction for the court to give you bail. And so if an individual is arrested anywhere, the police has no right to keep him for more than 48 hours before he is brought before a court of competent jurisdiction. And this is the combined effect of Article 14 and Article 19 of the Constitution. And so that is what they adhered to. The courts, the circuit courts, denied the bail application of counsel for Abronye and remanded him to appear, that is tomorrow. In fact, the police made a claim or made the case that they need more time to investigate the charges they have proffered against Abronye, which is quite interesting because these are charges that hinge on an act. So if you see a video of me insulting the president and say that the president is whatever, and you charge me for offensive conduct conducive to a breach of the peace, all you need is the video. You have seen me in the video, you have kept me, you have asked me questions. I do not know which other investigations the police intends to conduct into this matter, but that was the case that was made before court, and so they told the courts that they want to keep, or Abronya has to be kept in custody to tomorrow. And so this is the offense in Act 29, Section 207. It says that a person who in a public place or at a public meeting uses threatening, abusive, or insulting words or behavior, and this is where it's very interesting, with intent to provoke a breach of the peace, or by which a breach of the peace is likely to be occasioned, commits a misdemeanor. Now, in Ghana's rank of offenses, we have a first-degree felony, we have a second-degree felony, and we have a misdemeanor. Misdemeanor is what would say an offense that is the least serious of offenses we have. And so the maximum per Act 30 for keeping somebody upon conviction is 3 years. That is, unless another law specifically mandates that even though an offense is a misdemeanor, the person can be kept for more years. And then this is Section 208. It says a person who publishes or reproduces a statement, rumor, or report which is likely to cause fear and alarm to the public or to disturb the public peace, knowing or having reason to believe that the statement, rumor, or report is false, commits a misdemeanor. So this also is a misdemeanor. I do not see how, but this is a value judgment, I do not see how saying that the IGP is corrupt may lead to a breakdown in security or public security. But I think these are opportunities to test the legal system and see
well, perhaps the point is people will lose confidence in the IGP and they'll take the law into their own hands. Perhaps, I mean, if you want to stretch it.
Yeah, but that's the point, stretching. So in the US, they had occasion to decide a similar offense. And it was in the Supreme Court. In fact, the Justice Thurgood Marshall, who was the first black justice of the American Supreme Court, sat on that matter. And it was the case of Papa Christo versus Jacksonville.
Are you talking about Chief Justice John Marshall?
Thurgood Marshall.
Thurgood.
No, not
John
Marshall, the old one.
1972.
No.
So I was
Thurgood, the first black.
Okay.
In fact, he
Clarence Thomas is not the first black.
No, Clarence Thomas is the second.
Oh, I
Thurgood
see.
Marshall was the first. So Thurgood Marshall died,
Mm.
and Clarence was appointed to sort of replace to keep that balance. On the bench.
Okay, I see.
So in this case,
what's the name? What do you pronounce that
Papa
name?
Christo. It's Greek.
It sounds like Ghanaian, Papa Christo. Okay.
The city of Jacksonville.
Yeah. And what
so the
happened in
city of Jacksonville had enacted a law that's banned what we call it had a vagrancy clause. So people who loiter, people who are found walking aimlessly, it made that a criminal offense.
In which state?
It was in the city of Jacksonville.
Jacksonville, okay.
Yeah. And so the matter went up to the Supreme Court. And
Federal
the Supreme
Supreme
Court. Federal. It was a bench of 7.
Okay.
Justice Rehnquist and another judge did not sit, but it was 7. 7-0 majority. The Supreme Court in the United States held that any law that gives law enforcement agencies the room and the wherewithal to convict as and when they wish is vague and consequently should be declared as unconstitutional. There was an attempt to apply this in Ghana in the case of Chachuchikata versus the Attorney General, where Chachuchikata sought to pray before the Supreme Court that the offense of willfully causing financial loss to the state is unconstitutional because it's vague, willful, and all that. But the Supreme Court held that we can interpret what willful is, we can interpret what causing loss is. And so in that instance, that attempt to
causing loss is a mathematical outcome.
It's a mathematical outcome. And so you look at the fact that maybe procurement laws were not followed, and consequent to that, there was a loss occasion to the state. And so it is simple.
The contract was not done.
It wasn't done properly. It didn't go to parliament. There was no opportunity for it to be audited. You bypass your chief director of the ministry, all those things. And so the Supreme Court in this instance did not apply the vague test, the test of vagueness in Ghana. However, it does not mean that that argument is lost on us, because the general principle in criminal law is that criminal laws are supposed to be interpreted strict and firm. And so, for instance, it's similar to the Bible. When God gave Moses about over 600 laws, the rationale behind God giving Moses and the Israelites those laws was to ensure that things were very, very specific. So, for instance, there was not a lot of room for Aaron and the prophets to do a lot of interpretation in those things. So God will say, if you wear a garment where 2 fabrics are mixed, you must be stoned. If a male wears a female attire, you must be stoned to death. That's the nature of criminal law. And so it raises a jurisprudential discussion as to whether a law that says that law enforcement agents can say that any act which is likely to cause fear and alarm to the public or disturb the public peace knowing or having reason to believe that the statement, rumor, or report is false. We should have the debate that does it give law enforcement agents a lot of room?
The discretion is in the word likely.
Likely.
But the report which is likely, that's what the discretion is.
Yes, the discretion.
Because then they make the determination whether this report
is
likely.
Yes.
The likelihood, using the word likely to apply to an offense
it's a problem. Because an offense
the word likely cannot be applied to an offense. Offense is specific.
Yeah. So, for instance, if you look at this definition of murder in section 46 of Act 29, it says that a person who causes harm unlawfully to another person and that harm causes the death of that person commits murder. It's a simple and straightforward. But in this instance, by you giving law enforcement agencies the room to make that determination may be a problem. So I think that it is true, publication of false news must be, or publication of false news that indeed has the potential to...
It's a concern,
It's a concern, it's a public concern. I think what the law making body, that's the legislature, should do is have a more expansive definition of what publication of false news is. And more specific. So what publication is, the various media that publication may be done, the specific statements that qualify, and maybe putting something out that is false. And when we even say likely, what is it? So for a very good example is Rwanda. After the genocide, they were specific on issues. So if you go to the Rwanda, their laws are specific. They'll tell you that issues relating to tribe,
you cannot talk
about it. So here we now have to have a discussion. Is it inciting?
And even which people qualify to be prosecuted? Because if I stand here and say Minister XY has done this, it carries more weight than a young man playing, do you know what totals is? The ball, playing totals at circle and says that, oh, this minister has done that.
Yeah, the circumstances.
The way you approach my saying it should be completely different from you approach a young man who is saying it. Or some young man running to a political rally, shaking his flag and saying something about other people.
Exactly.
It's very different from a journalist who sits on the